Well, a timely lecture is being held in Wellington by a leading Indigenous scholar who's well placed to talk about the possible implications the TPPA may have on the Treaty of Waitangi. Canadian Professor John Burrows is also a keynote speaker at an upcoming symposium on the treaty being held at Parliament next week. He's a proud member of the Chippewas of Nawash First Nation and is an internationally respected legal expert on understanding the way laws work, particularly in the context of Indigenous people. He joins me now to talk about his work with students and how laws and justice impact on Indigenous communities. Professor John Burrows, hello.
Hello.
I meant to check the pronunciation of your First Nation organisation, Chippewas of Nawash.
That's right.
Very good. Welcome to New Zealand.
Thank you. It's good to be here. I'm really enjoying this weather down in Wellington here.
Oh, you don't hear that very often. No, I'm joking. I lived in Wellington for 8 years and loved the weather mostly. You're in a good position to give us some international context to the Treaty of Waitangi. How does the document compare with other countries and the partnerships that they've formed?
Well, there is some similarity. On Vancouver Island, where I'm living right now in British Columbia, there was treaties signed there in the 1850s, and they actually used some of the New Zealand land registry forms as a part of our treaty, and so people had knowledge about what was happening in New Zealand, and that influenced treaties taking place around Victoria, British Columbia. Likewise, my great-great-grandpa signed a treaty in 1854 in Ontario, and many of the similar provisions that are in the Treaty of Waitangi find place in the treaty that my great-great-grandpa was a part of.
Have those treaties been honoured? Have they been points of conflict or partnership?
I think it's all of the above. There are moments where the honouring happens. There was promises that we would get reserves and the ability to be able to fish and to be able to have education as a result of other people coming amongst us, and some of those things in the beginning had fulfillment, and then now in our history are starting to see fulfillment again. But like the Treaty of Waitangi, there was a longer period where there was a real challenge in holding those provisions to effective operation. And so it's similar in both of those senses, in that we've had some moments of fulfillment and other moments where there's just been a departure from those principles.
Here in New Zealand, one of the big issues was the conflation of governorship with sovereignty. The Maori thought they were giving away governorship. The settlers thought they were getting sovereignty, and that's where the problem seemed to have stemmed from in many cases. Was there a similar issue in Canada where you're from?
There was, although in the treaty here, what's interesting is you have two versions written down on paper, both the Māori version and the English version, whereas in Canada you would have the interpretive differences, but they were always recorded only in English. And so for a long time that English version became the one that people regarded as authoritative, but of course it didn't accord with the oral promises that were given to the people at the time of the treaty, which they remembered in their own traditions. And of course there were missionaries and traders and others that took notes of the meetings and said other things were promised. And so what the courts have done is they've developed canons of construction to give these English agreements large, liberal, and generous interpretations, resolving ambiguity in favor of the Indians, to recognize that we don't have the bilingual document like you have here in this country.
You talk in your work about getting our laws from places other than the courts and Parliament, and is oral history one of the sorts of things you're talking about?
It is. In fact, when I was growing up, what I learned about how to live well in the world and what were some of my obligations to the land and to my family and to others came from a tradition that was really located on the land. So my mother or my grandfather would point out different features on the earth, and he would tell me stories about those things. And in the stories about maybe a rock or a plant or a body of water would be ideas about how I was to conduct my own life. And I came to appreciate in those stories that I was learning a lot about our own legal tradition. That is, what are the principles or standards or criteria to be able to judge what to do or what not to do. And so teaching Indigenous law on the land really has that component as a part of it, which sees the textbook or the legal archive as actually being literally written on the earth.
One of the issues for you is that law can't capture spiritual meaning or spiritual value. Is that something you see as an issue here in New Zealand too?
Yeah, I think there are ways to try to get at the translation process. In Canada, the courts have said that the role of our interpretive mechanisms are to create a reconciliation between the Crown and Indigenous peoples, because you can't always bring these concepts over in a way that would be understandable. So, to talk about spiritual issues, for instance, in a court just doesn't have any standing, any justiciability. But if you do a translation process and you're saying, well, hold on for a second, underneath that spiritual principle is actually a good set of reasons for why things are done in that way, you can try to reconcile the spiritual meaning with the more secular meanings that might be found more generally in the community right now.
What about teaching law? Do you think there are alternative ways to teach law, particularly in regard to Indigenous students or Indigenous issues?
Yeah, I think, again, taking students out into the land and having intensive, almost clinical-like experiences where they're able to learn a literacy that starts to explain what the landforms mean, what they might communicate, how the standards of law might be generated from them, is something that you can't do in the same way when you're sitting in a classroom or a law library. I'm really intrigued by some of the recent treaty settlements here where rivers have been designated as having legal personality, or tops of mountains. And if they are living in that way, that means that there's something they can communicate to us. And the challenge is to be able to find the language and the intellectual categories that enable us to involve in listening and understanding some of those principles that are associated with those living beings like the rivers, the mountaintops, etc. One of the things we've been developing in Canada is a joint degree in both the common law and Indigenous legal traditions, so that students can graduate at the end of their period with the knowledge of both legal systems and how they might interact with one another. In Canada, we have both the civil law in Quebec and then the common law to the rest of the country, and students can take a degree where they can compare and contrast both the civil law and the common law. And up till now, it's not been possible to do that with regard to Indigenous legal traditions. And so one of the things that we're working on is that similar way of putting those laws beside common law and civil law so that students can actually begin to get accredited in those systems. As you know, having graduated from law school yourself, though, when you just get out of law school, you're still a baby in terms of learning law. It takes a lot of years of practice, but nevertheless, there's something about that initial orientation of law school that can equip you to be able to learn and start to apply those laws.
Yes, I know you're, I think, a guest at Victoria University in Wellington. I should say that Waikato University, where I went, was very forward-thinking in these areas. But it does raise people's hackles, doesn't it, John, when you talk about things like parallel legal systems, because there's a concern that if you have one system for one people and a separate system for other people, that the rule of law is diminished and that somehow people operating under the first system may not have the same advantages, or Indigenous people may be able to get away with things that they may not be able to get away with in a traditional system. And what do you say to those objections?
I think that they're very important to be acknowledged. Law can be a good thing and really help to facilitate order and peace, but there are instances where law is used to manipulate or to oppress or to marginalize others, and that can happen not only within the common law, but it can also happen with Indigenous law as well. And so one of the things that's necessary is to be able to bring these ideas more prominently to light so that it's more difficult to engage in that kind of manipulation or oppression or hiding the ball, as it were. And as you bring greater transparency, greater understanding to the legal traditions, you can see when someone's trying to pull a fast one on you, both in the common law context but also in the Indigenous legal context. So it's the very reason for engaging in these kinds of processes is the kind of important critique that you've mentioned. if we don't do the hard work of making sure that there are systems of order in the way that we proceed with these legal traditions, it can lead to inequality and it can lead to separation. But if it's done right, it can lead to harmonization and reconciliation. And again, in Canada, we have that example between the civil law and the common law interacting together quite well. No one's really put out by the fact that we have two legal systems there. And it's just a matter of recognizing that a third legal system operates under the radar and bringing that above the radar so that, again, with its prominence, there is an expectation of greater order that attaches to that rather than some of the nefarious things that can occur when things go underground.
As an expert on Indigenous law and Indigenous issues, do you have a view on the Trans-Pacific Partnership and how that might impact your people and Māori in particular?
I think there's still so much we don't know about that issue. Canada signed this February 4th as well onto the TPP deal. Our Prime Minister, our Trade Minister anyways, said that signing and ratification are two different things. So we've now signed the agreement. But he said in order to ratify the partnership, in order to ratify the deal, there has to be work in Canada that's now done in consulting with Indigenous peoples, which is a part of our law in Canada, as I know as it is here, and then accommodating the treaty and other constitutional rights that we have in our country to ensure that the TPT, when it's implemented, is in accordance with our broader and higher sets of laws that we have as Canadians. And so that's how it's proceeding in our neck of the woods.
Wait and see, huh?
Mm-hmm.
Well, Professor John Burrows, lovely to have you in the country, and thanks so much for your time this afternoon.
It's great to talk with you too.
And you can hear Professor Burrows giving a public lecture in Wellington tomorrow night from 5:30 p.m. to 7 at Victoria University.